16 gunshots. Was that a justifiable use of force, or was this murder? We'll talk about that in a minute. I want to break down this case right now with a very special guest. Joining us, a very familiar face here on the network, juvenile judge, trial attorney, and host here on the network, Judge Ashley Willcott.
Hi, Jesse.
Great to see you. Welcome back to the new set.
Thank you for having me. It's beautiful.
I want to ask you a question. First, once I have you here, the judge in the police cover-up trial, because it's so tied to the Jason Van Dyke trial, we thought that she was going to come back with a verdict on whether or not these police officers actually covered up the shooting. It's been delayed, but we haven't given a reason why. What's going on?
So I don't know why, and it's interesting she hasn't made any statement, but I'll tell you this. One of the things I would do if I were the judge was to set out the statute, put all the facts, match them, and go through every piece of evidence. That can take a lot of time, and who knows how many other trials she has had to preside over and other work that she's had. Maybe she just hasn't had sufficient time to do that thoroughly enough for her to feel like it's the best decision.
I know there's been speculation that she might be preparing resources for the verdict, because we know when Jason Van Dyke's verdict came down, all of Chicago was braced. You think that something like that is happening as well?
You know, it could be. I've said my gut is that the conspiracy charges aren't going to stand based on the evidence. I'm not saying I'm right. I'm just saying that would be my prediction. If that's the case, I think she would be wise to have some resources in place.
All right. Well, we know there's going to be a hearing there. We expect a hearing in that courtroom at noon. But right now we're focusing on Jason Van Dyke. We just played you the prosecution's opening statement. Very, very powerful. Let's move on now to the defense's opening statement. Take a look.
The decision shows lawful. There is no crime. The government talks about 16 shots. Well, they didn't charge him with excessive force. They didn't charge him with shooting too many times. They charged him with first-degree murder. And you're going to see that Laquan McDonald shot, the first 3 shots hit him in the front. And the first or second shot killed him. We know that after the fact. We're going to have evidence of that. Now, as a black boy, obviously Jason Van Dyke is white. The government wants you to think that this is a racial issue, because that's more inflammatory. Race had nothing to do with this. Race had absolutely nothing to do with this. And there will be no evidence whatsoever to suggest that race is a factor.
Ashley, you tell me, did race have something to do with the shooting?
I think that the public's perception is that it did. I think that there's an assumption that it might have or that it did. But I think the reality is, when you listen to the prosecution's opening statement, that's not what the prosecution is saying or relying on.
Trying a police officer, is that different than any other kind of case?
Absolutely, because a police officer, first of all, there have been very few convictions of police officers, as you well know, that have actually been involved in police shootings. That's number one. Number two, the standards are different because they're acting in their official capacity, so it's a whole different legal standard of whether or not they used reasonable force in that capacity.
And I know that all of Chicago was watching this trial. They were waiting for the verdict. We're going to reveal that later. But right now, we still have to focus on this case from the beginning. And one of the things that we keep playing, and one of the most important pieces of evidence, if not the most important piece of evidence, was the footage of the actual shooting. One of the arguments was you can't judge anything by a TV screen. Well, let's see an expert, a use of force expert, Yuri Patrick, who talked a little bit more about this. Take a look.
As a use of force expert, was that an appropriate action by those officers calling for the taser?
I think so, yes. I think the officers in general on present were acting appropriately, restricting his movement, hemming him in, trying to isolate him to an area that was not populated.
When you viewed People's Exhibit number 8, and I'm not going to play it again, but did you note the short time period from when Officer Van Dyke's vehicle arrived and when you first visibly observed shots being fired at Laquan McDonald?
Yes, it was very short.
And based on your expertise as a use of force expert, you indicated that one thing that officers are required to do is to assess the situation. Is that correct?
Yes.
Based upon reviewing this case and those actions of Officer Van Dyke, the short time period, and exiting his vehicle and firing his gun at Laquan McDonald. Do you have an opinion regarding that behavior and the decision to shoot Laquan McDonald?
Well, police officers have to get out of their vehicles. My issue with Officer Van Dyke is his decision to shoot. It was not, at that moment in time, in those circumstances, the standard imminent risk of serious injury or death was not present, and the use of deadly force was not necessary at that point in time.
According to that use of force expert, Jason Van Dyke was not justified in firing and shooting and killing Laquan McDonald. Now, that's a big point for the prosecution, but is that the end-all be-all, having this expert come on and say that?
It's not, because they always use experts for both sides. So I'm assuming we might hear from an expert for the defense that's going to say, hey, it was completely reasonable, and then a jury has to determine which expert to believe.
Is it impossible to determine whether or not this was an appropriate use of force unless you are Jason Van Dyke?
Well, that's one thing you have to keep in mind. That's a very valid point. It has to be what was reasonable in his mind. And so that's what they have to consider. Whether you think it's reasonable or not really isn't the issue as a jury or the judge in this case. Instead, or the jury in this case. Instead, it's what's reasonable in that officer's mind, in Van Dyke's mind.
Well, we know that we have a young man that was shot and killed and shot 16 times. And the question is that excessive? If he shot him one time, would it be a different kind of case? But shooting him 16 times, I know there's a back and forth about whether or not if there's a threat you unload the clip, but I'm curious what you think about that.
I don't think that you do unload the clip when there's a threat. You do what you have to do to subdue the threat so that nobody's in danger. And I would submit 16 times is an awful lot to shoot somebody that's on the ground.
And we're talking using the word threat. That even became a question whether or not Laquan McDonald was even a threat. And we'll talk more about that. So let's stay tuned. We'll be right back right after this. All right, so that was Jason Van Dyke under direct examination, explaining his perception of what happened. Let's see how he did under cross-examination. Take a look.
That's your testimony?
No.
What is your testimony? Why did you shoot?
With his actions with the knife or his actions in total?
His actions with the knife.
Well, his actions with the knife also were his actions in advancing on me. He brought the knife down from his waist level up towards his left shoulder like this.
Okay, you were interviewed that night by Detective March, isn't that correct?
Yes.
And that night when you were interviewed by Detective March, you told him, isn't it correct, that McDonald raised the knife across his chest and over his shoulder, pointing the knife at you, correct?
I'm sorry?
Did you tell that to Officer March when you were interviewed that night?
I'm sorry, could you repeat the question, please?
Okay. You told Officer March when you were interviewed that night that McDonald raised the knife across his chest, over his shoulder, and pointed the knife at you, correct?
You know, I don't remember exactly what I said immediately after the shooting. I do remember talking to Detective March. I remember telling him what I just demonstrated to you.
So you never told him that he put that Laquan brought the knife over his shoulder and pointed it to you. Is that what you're saying?
Again, I don't remember exactly what I said immediately after the shooting. I was still in shock.
And you told that to Dr. Miller when Dr. Miller interviewed you, didn't you?
What did I tell him?
You told him that he brought the knife up over and across his chest and was pointing it at you?
Told Dr. Miller that he brought it up across his chest like this, yes.
Okay. Now you've sat here for several days. Where do you see that on the video?
I don't see a video.
You sat here for several days and watched several videos, haven't you?
Yes.
Have you ever seen Laquan McDonald do that on one of those videos?
The video doesn't show my perspective.
The video doesn't. How about the animation? Let's play that, the animation that I'm going to show, Your Honor, what's been previously entered as defense exhibit number 10. We're going to skip to your perspective. There's your perspective, right? Is that it? You want me to play it again?
No, it's not my perspective because it's showing the back of my head and not from my eye level. It's not showing what I saw. It's showing the back of my head and above me.
Okay,
So it's not my perspective, miss.
Let me ask you this. It says officer view on that, and that's what your expert presented as your view. Is that correct?
I'm sorry, miss?
That's what your expert presented as your view?
That's beyond my...
Were you sitting here the last couple of days when your expert testified?
I was here, yes.
Okay. And he testified that this was from your viewpoint, correct?
I don't know.
And do you see in that video at all Laquan McDonald raising the knife?
No, I don't.
All right, Ashley, did he get trapped there? I mean, he's like, oh, the video that we've all seen, that doesn't show my perspective. Then they show this animation. He goes, that doesn't show my perspective. Did he get caught up in a lie, maybe?
I think he did, and I think that he's trying to make it up as he goes along. But remember, whenever a defendant testifies, Jesse, it's a live performance. They don't necessarily know what the prosecution's going to ask, and they have to make up the answers or think of their answers on the spot. And I think he did just get caught with, oh, well, even though there's a video of it, that's not what I was feeling.
How do you do on the stand?
I don't think he did well. I did not find him to be very credible. Watching him and the way he answered, I just didn't believe what he was saying completely.
Well, then again, it might have been his perspective. He saw something that no one else saw, something that maybe the video, the animation, no one saw. Then again, at the end of the day, we have a man who was shot 16 times. Was this self-defense? Was this a reasonable use of force? Was this murder? Let's see what the verdict was.
With this understanding, will you please read the verdicts?
We, the jury, find the defendant, Jason Van Dyke, guilty of second-degree murder. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, first shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, second shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, third shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, fourth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated.
So he was found guilty of second-degree murder and 16 counts of aggravated battery. When you listen to this, were you surprised? I know all of Chicago was waiting for that verdict. It was second degree that he was found guilty of, not first. What was your reaction?
I was not surprised that he was convicted, Jesse. And so one of the things, again, when a defendant takes the stand, it takes the jury's focus off of did the prosecution prove this without a reasonable doubt to do we believe the defendant in this case? And I think the jury's verdict means they did not believe what he says his perspective was.
On Defendant Speaks Day, was it valuable for him to take the stand? Was it a good thing? Did he have to? Did it help him? Did it hurt him?
Well, I think hindsight's 20/20. I think it hurt him in this case, and I think he just, again, did a jury believe his version of events? Ultimately, no, they didn't. So I do think it hurt him in this case.
And I guess the question is, his sentencing is set for January. What could he face?
And I don't remember what I think he can face life, and I need to look for sure because I can't recall, but I think life is what he's facing.
Do you think, though, with this kind of case and all the factors put into it, you think he would get whatever it is the max charge is, the max sentence, or would it be somewhere on the lower spectrum, middle spectrum? Because if you're sitting there as the judge, you have a lot to consider here.
Absolutely. And, we have to look at aggravating circumstances and mitigating circumstances for sentencing purposes as a judge, or if the jury does it. And I think in doing that, they're going to take everything into consideration. But remember, he was convicted of so many different charges. I think he faces the maximum.
The judge in this case denied the defense's motion for an acquittal, to have the judgment thrown out, the conviction thrown out, and for a new trial. So that avenue is done for the defense. Now they have to decide whether or not they're going to appeal it and what the issues are there. But when we come back, let's talk about a related case, the police cover-up case in the Laquan McDonald shooting. We'll be right back. The question there is whether or not defendant March called this guy and gave him false information about the shooting. We'll talk about that in a second. Right now, let's move into the motion for directed verdict, the defense's option to try to have this case thrown out before they put on their case. Let's see how it went.
He was at the scene that night. And according to the police reports, which the state introduced into evidence, Your Honor, that David March was overseeing the collection of evidence done by the evidence technicians that night. All 16 shell casings were picked up by evidence technicians under the supervision of David March. If he was conspiring to conceal the true facts, how about him picking up about 7 or 8 shell casings and putting them in his pocket? How about taking that video from 813 Robert and throwing it in the middle of Lake Michigan? It is shameful that David March, an innocent man, is sitting here charged with these crimes when he gave all the evidence to these prosecutors. And by the way, the goal of this conspiracy, according to the special prosecutors, is to shield Jason Van Dyke from investigation and prosecution. That's a laugh. You know from the evidence, Judge, from the witness that testified, you know that the Cook County State's Attorney's Office and the FBI were conducting interviews in January of 2015. You know that not only was the Cook County State's Attorney's Office involved in an investigation, so was the U.S. Attorney's Office. You know from witnesses who testified and were impeached by federal grand jury testimony, the federal government was involved in this investigation in 2015. You know that in addition to the FBI, the U.S. Attorney's Office, the Cook County State's Attorney's Office, the Office of the Inspector General was taking sworn statements from people in this case. To charge David March and others that they are hiding facts from independent criminal investigators, that's a laugh. That's a joke. A bad one, but that's a joke. But here's the best. Here's the best, Judge. The police reports submitted by the state with David March's name as the author belie the allegation by Briggs that the word lunged was used. Nowhere in David March's reports does he use the word lunge. No witness who David March interviewed and documented on a general progress report said the word lunge. Lunge didn't come from David March, nor anybody he talked to. You know who it came from? A media person named Pat Camden, who worked for Chicago FOP, not the Chicago Police Department. There's no checks and balances for the media. David March didn't say lunge, never wrote it. Why does Earl Briggs testify? Because their case stinks.
An impassioned argument, direct motion for directed verdict. That was denied. Yeah, the judge came back, Ashley, and said, no, we're not throwing this case out just yet. Continue on. That doesn't necessarily mean, though, that she's going to come back and find them guilty.
Not at all. What it means is, as a judge, you have to take each individual motion and each piece of the trial separately, put the rest aside. So she based it on the evidence that had been presented. She denied that. She now will hear the rest of the evidence to then make a decision.
And were you surprised by that?
No, because, defense always makes a motion for directed verdict. There's no reason not to, because you want to ask the judge and say, look, there was not sufficient evidence for there to be a finding in this case or a conviction or a verdict. So it's not atypical they ask. Typically, they're denied.
I want to step back for the clip that we were playing before with Earl Briggs. So it was alleged that David March had called him and said, hey, Laquan McDonald lunged at Van Dyke. We all know that wasn't true. And the question back and forth what the defense attorney was making was, how do you know that was David March who called you? Is that an effective argument?
Well, I think that it puts into question the credibility of that witness. And so he's trying to say to the jury, look, he doesn't know who it was that called. And in fact, you had two different reports that said two different things. All he wants to do is try to convince that jury this witness is not credible, don't believe him.
We expect a hearing maybe in about 5 minutes, 10 minutes or so in this police cover-up trial to determine when the verdict will happen. Ashley, I know we don't have much time. What do you can expect, 10 seconds or so?
I think the judge is going to reset the date and may not even give a reason why the verdict is not ready.
Yeah, we were expecting it this week, but not. Now, Ashley, I know we're signing you off, but you're coming on at about 3 o'clock to host the show.
Yes, sir.
I am signing off right now. Bob Bianchi is signing on, and he's going to guide you through the next trials that we're covering here today on our very special program, Defendant Speaks Day. And again, we're covering some of the most interesting trials where the defendant has taken the stand. So far, what we've covered, it hasn't worked out so well for the defendants, Shayna Hubers and Jason Van Dyke. But what about Leon Jacob, George Birch, and Roy Oliver? We'll have to see. Stay tuned here on Law and Crime.